Good afternoon, this is Sean Golding with Golding & Golding, here to focus a little bit on FBAR willfulness versus non-willfulness, and specifically on the issue of whether reckless disregard, reckless conduct is considered willful. There was a recent case ruling in February in the case of Kelly, in which the Sixth Circuit Court of Appeals affirms the lower court and concludes that FBAR reckless conduct is willful and not non-willful. We've written about this case in the past, and we have a prior presentation on the issue of the defendant was alleged forced to repatriate money from overseas in order to satisfy a penalty. But this focuses specifically on the reckless conduct and why the court said taxpayer was willful. So brief history, FBAR penalties first, right? There's basically three primary categories of FBAR penalties for individuals and other filers. There's non-willful, which is what it will be the majority of the time. As a result of the 2023 Supreme Court ruling in Bittner, those penalties are limited to $10,000 per year, not $10,000 per account. And that $10,000 adjusts for inflation, so now it's around 14 and change. Then there's civil willfulness, okay? Civil willfulness is a lot less common than non-willfulness, but as this case shows, it does happen. Typically, a person has to be acted intentionally with willful blindness, reckless disregard. Those penalties are significantly higher. They can be maximum of 50% value of the unreported account. And there's also a floor. So even if a person had $40,000 in their foreign account, the IRS could try to take the position that it should be a minimal penalty of $100,000. That $100,000 also adjusts for inflation, but there's some argument as to whether the limitation can exceed 100% value of the penalty. Strike that. 100% value of the unreported account. So in this scenario that we just gave, taxpayers can try to make the argument that it shouldn't exceed 100% value of the unreported account, not 100,000. The third one is criminal willfulness. Now, with criminal willfulness, that's very rare. That's going to be a criminal scenario. You have to go to a jury of your peers beyond a reasonable doubt. In that type of situation, the penalties can be significant monetarily as well as being subject to potential incarceration. So looking at the case of Kelly is a case that is similar to another case in which the taxpayer had entered into OVD. But taking a step back, taxpayer had domestic accounts, closed the accounts, and opened a Swiss bank account. I believe it was Fitner, and it was about $1.8 million. He opened what's called a numbered account, which just basically means that the account will be identified via a number instead of a name, and that the bank holds on to the information instead of sending you those pesky monthly statements. So, out of sight, out of mind. The problem with a numbered account when a U.S. person is opening it is it could give the impression that the taxpayer doesn't want that information so that they can take the position that they didn't know. Unfortunately, that could lead to willful blindness, but that's the concept behind it. In this particular case, the facts tended to show that the defendant knew about the FBAR, was urged to enter OVDP, and he did. Unfortunately, he didn't complete OVDP, and apparently there were 2 years of FBARs that were still not filed. So in this particular case, why did the court uphold that there was recklessness was willful? Well, it's important to note that there's various other circuits. Obviously, this is the Sixth Circuit, and other circuits have found the same outcome, which is that reckless disregard, reckless conduct for FBAR is equivalent to willfulness, not non-willfulness. So when someone thinks of the term willful, oftentimes it conjures up the concept of intent. But what this case further shows is that you don't have to have necessarily intent if you were reckless, if you didn't, reach out to a tax advisor, try to learn about your situation. The courts can find that that's also willful. Now, what's important about this case versus other cases is that it is a large amount of money. It's a few $1 million, and it is Switzerland, which had a problem with the deferred prosecution agreement. So the government had been going after Switzerland for a while. And in this case, it's a numbered account. So when you mix that all in a pot, someone's not getting the information that the court believes they should in terms of going to an advisor. They are not filing the FBAR timely. They're opening accounts in Switzerland, and they're opening numbered accounts. The court came to the conclusion, based on that totality of the circumstance, that the taxpayer's reckless conduct would justify willfulness. It's also that idea that they don't want taxpayers running around and doing this with lots of money and be limited to the non-willfulness penalty. Another thing to keep in mind is OVDP is the Offshore Voluntary Disclosure Program, and they terminated that program back in 2018. It was an offshoot of the Voluntary Disclosure Program. But one thing when you read through the requirements is it requires full cooperation. And what the court was saying here is, based on the information they have, taxpayer allegedly did not fully cooperate with OVDP, and that just made it worse for him. For taxpayers who are out of compliance and have not yet been contacted by the IRS, there are various programs they can use to get into compliance. If they're willful, they would do the VDP. VDP is the Voluntary Disclosure Program, otherwise referred to as the Traditional Voluntary Disclosure Program. It's been around for a while, and it includes both domestic and offshore. Otherwise, there's various programs available, such as the Streamlined Filing Compliance Procedures, domestic and foreign. Both of them are for offshore accounts. Domestic means you're a U.S. resident for purposes of Streamlined. There's also delinquency procedures and reasonable cause. We got a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.